You're right. Cuts his defense off at the knees. Here's the clean, no-nonsense breakdown. He legally could not serve his own TRO, period. Under C.R.C.P. 4D, service cannot be made by, open quote, any person who is a party to the action. Close quote. Frederickson was the petitioner. That makes him a party. That alone disqualifies him from serving anything. No workaround, no good faith, no peaceful service theory. Why this matters more than he realizes? By admitting he was attempting to serve a TRO, he is admitting to 1. Engaging in an act he was legally prohibited from doing. 2. Initiating contact he was not authorized to initiate. 3. Approaching and following the respondent under color of a false legal premise. That doesn't excuse harassment. It establishes intent. His claim actively helps the prosecution. To prove CRS 189111C, the state must show intent to harass, annoy, or alarm, following in a public place. His own words now supply the missing mental state. Open quote, I was trying to serve a TRO, close quote. That statement proves he intentionally sought contact. He knew who the person was. He chose to approach anyway. He followed when the person tried to leave. That is textbook harassment. The service claim destroys his First Amendment argument too. Service of process is protected only when lawful. This was not. He was not a process server. He was not law enforcement. He was not a neutral third party. He was a litigant claiming fear. Courts do not protect, open quote, unlawful attempts to serve court papers, especially when they contradict a claim of fear, close quote. Trying to serve your own TRO is evidence of bad faith, not protected petitioning. It also blows up his credibility. A petitioner who claims fear then seeks out the respondent, approaches their vehicle, shouts at them, chases them across a parking lot, follows them into traffic, is not acting consistently with someone seeking protection. Judges notice that immediately. Bottom line, his own admission does not create a defense, does not negate intent, does not invoke constitutional protection. It confirms unlawful contact, deliberate pursuit, and a knowing violation of procedure. In short, the more he talks about serving a TRO, the stronger the state's case gets. If you want, I can also show how this kills any constructive eviction retaliation narrative, lay out how a PD will reframe this in court, or map exactly how this plays if he insists on testifying.